Okay.
Good afternoon to all of you who have joined us today. We welcome you to this webinar on practical handling and legal consequences of the sanctions against Russia and Belarus, organized by us, by ExportManager Online. First of all, I would like to thank the legal experts from Barnes and Thornburg and Graf von Westphalen today. They will look at the sanctions from the perspective of the United States as well as that of Europe. It was mid of February when the Eastern German Business Association, the Ostausschuss, reported really encouraging figures on foreign trade in 2021. The volume of foreign trade between Germany and Eastern Europe was more than 500 billion euros, about 20% more than in 2020. Russia was the third most important trading partner, with exports of 27 billion euros and imports of 33 billion euros, for sure, most of it oil and gas. And now, full stop. The terrible war in Ukraine has been going on for more than a month. The EU, United States, and many other countries have imposed drastic sanctions on Russia. These affect the exchange of goods, financial transactions, and sanctions against individuals, the oligarchs. The purpose of this webinar is how companies like yours are able to deal with the sanctions. Unfortunately, Jens Böhlmann from the German Eastern Business Association, he had to cancel. He has fallen ill. We wish him all the best for a quick recovery, but that does not matter, because we are glad and proud that such a concentrated legal expertise in sanctions has found together today. Please welcome, for sure, no applauding, Tanja Galanda. First of all, she's local partner at Graf von Westphalen. For 20 years, she has been advising German investors on their engagement in Russia, Ukraine, Belarus, Kazakhstan, and neighboring countries. Since 2014, she has also specialized in sanctions advice. Tanja is based in Berlin. Clinton Yu, based in Washington, is partner at Barnes and Thornburg. He advises clients on compliance with US trade and investment laws, including customs and import regulations, export controls, and economic sanctions. What is interesting, very interesting today. Also based in Washington, also partner at Barnes and Thornburg, Nick Galbraith advises domestic and international clients on a wide range of trade law issues, no matter how rapidly the regulatory environment changes. And last but not least, Marian Niestedt, partner at Graf von Westphalen in Hamburg. He advises on all aspects of German and European foreign trade law and customs law. One focus of his practice lies in the advice on compliance for companies. Wow, what an impressive concentration of expertise. But before we start, experienced webinar participants are certainly familiar with these, but anyway, a few etiquette for this webinar. We very much appreciate your active participation in the Q&A session. The best way is to send us your question in the chat. It is also sufficient if you just send us a chat that you have a question. You can find the chat function in the control panel of the webinar tool, probably on the right side of the monitor. There you will find in the menu chat, and in there is a field where you can type. Important is that you type in your name and your company, just to make sure that we can address the right person. I would then ask you to ask your question, and Felix, our tech pro, will unlock your microphone. In general, it is important that you set your microphones to mute. You certainly know this, and only open the microphone when you want to contribute something. The language of this webinar, as you can hear, is English, but of course, you can also ask questions in German. Two of our experts are German. And you don't have to note something because the session is also recorded. But we would like to invite you not only to ask questions, we also invite you to comment on what are the effects of the sanctions in your company. Just now a brief look at the agenda. At the beginning, Clinton, Nick, Tanya, and Marian will describe the current situation in the form of a short presentation. After that, we will discuss how to deal with the sanctions in the panel, and at the end, you will have the opportunity to ask your questions during a Q&A session. If you want to ask a question somewhere in between, just let us know. And now, I'm very pleased to hand over to our first expert. Good morning, Clinton. Good morning, Nick. In Washington, please go ahead.
Thank you, Martin. Good afternoon to you, actually, and to most of the audience. It's afternoon for you all. I'm going to go ahead and share my screen for the presentation, and just want to thank you, Martin, and the audience for having us today. Thank you for allowing us to do the presentation in English. That's much appreciated. And you are right about your previous comment. This is a terrible war that has been going on in Ukraine due to Russian aggression, and we have seen, sort of from a trade attorney perspective, Nick and I have seen, frankly, surprisingly swift, coordinated action in terms of sanctions from the West. And so for the first 15 minutes of this presentation, of course, us being U.S. international trade lawyers, we're going to talk about this from the U.S. angle, and then hand it over to Marian and Tanya for the EU angle. And so we could take up an entire 2 hours or even an entire day talking about U.S. Russia sanctions, but we do have a limited amount of time, and so we thought the most relevant topics would be to how U.S. Russia sanctions impact non-U.S. companies. And so the top 5 issues we want to address today are number 1, how U.S. sanctions affect not only U.S. companies, and number 2, how sanctions impact a wide range of global industries. Number 3, of course, the financial sector has been impacted by the sanctions, but it still makes certain business that's considered lawful very difficult. Number 4, we've already seen an uptick in enforcement activity, and we expect much more than what we've seen in the past. And then lastly, we'll just note a few important due diligence items and efforts that we think companies should note. And sort of with that overview, I'm actually going to hand it off to my colleague, Nick, and he's going to talk about the first 3 points.
Thanks. Thank you, Clinton. I'm very happy to be here speaking with you all this morning for me, this afternoon for you. As Clinton said, we're going to start by talking specifically about sort of the reach of these U.S. sanctions laws and how they can affect EU and German companies. And with that in mind, I should just start by mentioning who are sort of the key players on the U.S. side. The sanctions and export controls are administered by the Treasury Department's Office of Foreign Assets Control, or OFAC. They primarily administer the sanctions laws. And then on the export control side, it's the Commerce Department's Bureau of Industry and Security, or BIS. And the reason it's important to understand that there's sort of those 2 regulatory bodies is that sometimes a transaction, or often a transaction, will be impacted by both of their regulations, and you have to make sure that you're clear on both sides. And so with that in mind, I will start with talking about the U.S. export controls. These, as I said, are administered by the Department of Commerce's Bureau of Industry and Security, and they're called the Export Administration Regulations, or the EAR. And so these control consumer and dual-use items. And when I say items, I'm talking about goods, software, or technology. And so any companies abroad that are sourcing U.S. origin goods, software, or technology could very much be subject to these regulations and their restrictions. And so what is subject to the EAR? Well, first of all, it's going to be any item that's actually in the United States. So if it's foreign made, but then it enters the US, even in a foreign trade zone or even transiting through the US, it becomes subject to these regulations. So if you make a good in Germany and ship it through the United States, you have to make sure you're compliant with the EAR. It also applies to US origin items wherever they're located. So if you're importing goods, software, or technology from the US into Germany, the jurisdiction basically follows the item and attaches to that item, and you have to make sure you're compliant with the EAR. Interestingly, there's also other ways items can be subject to the EAR. So if you're making an item abroad and you're incorporating US content, if it's more than a de minimis amount of US content, that end item is also subject to the EAR. And the same is true for items that are produced abroad from certain US software or technology, and that are the direct products of that software and technology. Those can also be subject to the EAR. And these last two are particularly important in the case of Russia and Belarus, because the new rules with these export controls have created very specific and special rules on both the de minimis calculation and this foreign direct product rule. So for instance, whereas before certain low-level items wouldn't have been needed to be considered for purposes of de minimis calculations, they now have to be. And same thing with the foreign direct product rules. Certain items made from software and technology that was lower level didn't count before, and now they do. There are certain exceptions there related to allied countries. They're nuanced and complicated, and especially if you're doing manufacturing outside of the EU as well, they're especially important. Next slide, please, Clinton. And so now I'll turn to the reach of sort of the other side, that OFAC side I was talking about, US sanctions laws. And for those, you'd basically be looking for any US nexus that could trigger those US sanctions. And this is because generally, on their face, most of the provisions of US sanctions law apply to quote unquote US persons or activities within the United States. And US persons would of course include anyone in the United States, US citizens or permanent legal residents abroad. So in Germany, if you have US citizens or permanent legal residents, they would be US persons, and their involvement would make a transaction subject to US sanctions. And it also includes entities organized under US laws as well. And so in addition to that sort of on its face application to US persons or activities, another way non-US companies can be triggered under the sanctions laws is if they're engaging in any sort of conspiracy or evasion attempt to go around US laws, or if they quote unquote cause a violation by a US person. Sort of a major trend of enforcement that had happened with OFAC over the past few years had been non-US banks stripping out information about sanctioned parties being involved in transactions and processing them through US banks. And so there, those non-US banks were subject to major enforcement actions by OFAC for sort of blinding the US person to that sanctioned element so they couldn't block the transaction. So what are some potential US nexuses that could be involved in a transaction and create some, and would make OFAC have jurisdiction over that transaction? Like I said, it could be US citizens or permanent resident aliens, USD payments, exports from the US, and certain US person facilitation. In other words, you call up an engineer in the US for assistance on a transaction that involves a sanctioned element. And then even where there would be no quote unquote violation of US law and penalties for violation, there is still certain conduct by non-US persons, not even involving the US, that is quote unquote sanctionable, meaning the US could place your company on the restricted parties lists. So that could include providing goods or support or services to persons who are already sanctioned by the US. Next slide, please. So now turning to what these actual sanctions are for purposes of Russia, they're already impacting a wide range of global industries as they stand today. From the EAR side, the export control side, it impacted a whole host of different industries such as telecommunications, computers, information security, which could include, certain software that involves encryption, the avionics, marine, aerospace industries. All of these have been targeted, and even lower level controlled items now require a license. Also, luxury goods require a license if they're subject to the EAR. And there are also expanded controls on military end uses and end users. And of course, the financial, defense, and energy industry are affected as well. On the US side, some imports have also been restricted in the energy sector, and then very targeted to seafood, alcohol, and diamonds, at least for now. Next slide. So just talking a little bit more about those financial sanctions. I think this is something that most people are pretty aware of, but in coordination with the EU, the US has also placed sanctions on many major Russian banks. They've added them to the specially designated nationals list, or SDN list. Once a bank is on the SDN list, no US persons can have any involvement with them whatsoever, and they can't make any payments through the US. They're effectively blocked from that system. And even more, their property is blocked and can't be moved. There are other types of sanctions as well that are non-SDN sanctions, so not a complete block, such as debt and equity restrictions and things like that. And then we also have a ban on the supply to Russia of US banknotes as well. One other thing I would just mention real quickly is that beyond what's strictly prohibited under US law, given the focus on the financial sector by OFAC over the past several years, financial institutions tend to over-comply. So for even lawful business, you should expect lots of questions and due diligence requests from banks for any Russia-related payments that may involve US banks or US dollars. And so with that, I will turn it over to Clinton.
Thank you, Nick. So as you can see from what Nick described, we have a broad range of US-Russia sanctions, and there's an interagency effort to enforce these new sanctions. But not just within the United States, there has been sort of this multilateral coordination from the US Treasury Department and the Department of Justice to join together and create what's called the Russian Elites, Proxies, and Oligarchs Multilateral Task Force, or REPO, which I think is a very clever name for it, involving the US, of course, Australia, Canada, Germany, France, Italy, Japan, UK, and the European Commission. So a very coordinated effort there. Specifically from the US side, the Department of Justice has formed a task force. They named it Klepto Capture to enforce sanctions and export restrictions against Russia. And so what you'll see from this effort is you'll see a lot of the enforcement agencies come together to seize, to identify, seize, capture certain assets belonging to Russian oligarchs that are sanctioned, addressing virtual currency, cryptocurrency, and those efforts that are trying to skirt around US sanctions. They're trying to identify those efforts as well. Those are just some examples of what they've been involved in. And so if you're a company in the US, of course, you would be subject to these fairly significant monetary penalties. OFAC administers penalties of $330,000 per violation. Under the EAR, administered by the BIS, that's up to $328,000 per violation, and these are adjusted for inflation. And of course, criminal penalties up to $1 million per violation, 20 years in prison or both. And you know, I mentioned that these penalties apply to persons in the US or US persons. And so we're speaking to primarily perhaps non-US companies. And so you're wondering, well, to what extent can the US government come after us? Certainly if your company has a presence in the United States, or if you're a person that travels into the United States, you could find yourselves subject to these penalties. But also these agencies have the discretion and authority to detain and seize your merchandise. If, for instance, they come into the possession of the United States, you can also lose certain privileges. So, you know, from the US side, you have denied persons, they lose their export privileges. Outside of the US, we have, as Nick said, you have SDNs, the specially designated nationals, against mostly Russian companies and individuals. But if a company, let's say in the EU, assists or is involved in business with these sanctioned individuals, they can find themselves as a target or a threat from the US of secondary sanctions. So you yourself, while perhaps you're not technically in violation of US sanctions law because you're assisting or facilitating or somehow supporting a sanctioned person or a company, you yourself might find yourself as designated on the SDN list. Likewise, for the Department of Commerce, we have this entity list where persons in the US, items subject to the EAR cannot be exported to entities on the entity list. And so you can be placed on that list even though you technically may not have violated US export control laws. And we've seen a lot of recent examples of the US government taking enforcement actions and warning the public, frankly. And so one thing, you know, you see a lot of companies exiting Russia. Is it because their operations in Russia are in violation of US export control laws? Not necessarily, there's publicity issues. And so BIS has been quite active. Actually, I rarely see BIS tweet about these kind of things, quite active in communicating to the public that they are taking these stepped up export controls and sanctions very seriously, such as this example here. And then also on March 18th, just recently, the US Commerce Secretary Raimondo, she identified nearly 100 aircraft that flew into Russian airspace that was in violation of the EAR. And that's because the aircraft themselves are subject to the EAR, which is why they were in violation of it. And because of that, there is this general prohibition under the EAR, General Prohibition 10, that if you have something that has violated the EAR, you can't do anything. You can't even service it. And so she warned that if you, anywhere in the world, in the EU, in China, wherever, if this aircraft comes to you and you service it, refueling, maintenance, repair, provision of spare parts, that in itself is also prohibited. And she sent this warning to any person, anywhere. Could be subject to the fines that I mentioned, the loss of export privileges or other restrictions. And so what is a company to do? What is a non-US company especially that has to comply with not only the EU sanctions, but now has to worry about US sanctions? Well, you have to step up your due diligence efforts, and we can talk more about that in the roundtable and the Q&A. But just some items to highlight for you. Number one is the 50% rule. This is a challenge because under OFAC, entities that are owned 50% or more by SDNs are also then now considered SDNs. So the subsidiaries, wholly owned subsidiaries of SDNs are also SDNs. And the SDNs could be in various third countries. So you may be dealing with a non-Russian company. Do you know what the ultimate ownership chain looks like? Have you done your diligence to figure out if ownership is 50% or more owned by an SDN? Also, be careful about this sort of issue of blocked persons acting on behalf of non-blocked entities. And sort of an example that I can remember from a few years ago was an Exxon contract in Russia, where the company itself was not blocked, but there was an executive who was blocked, and the executive signed the contract with Exxon, and so that was an issue in dealing with a blocked person who was acting on behalf of a non-blocked entity. Just something to keep in mind. And then also geographical certainty about doing business in Ukraine. So Ukraine as a whole is not comprehensively embargoed, but there are certain regions that are Russian controlled, Crimea, Donetsk, Luhansk. So do you know the address of the customers or vendors you're dealing with in Ukraine if you do continue business in that country? Third, there are transshipment risks, and transshipment risks have always been a big issue in trade compliance. But we saw Commerce Secretary Raimondo warn about China. You know, China, is China going to help Russia? Are they going to help get certain technology or assets to Russia? And so keep in mind, if you're doing business with countries that might be a little bit too close with Russia or allies of them, is there a transshipment risk? And then lastly, this fourth point is kind of nuanced. It's under General Prohibition 8 of the EAR, but it basically lists several countries through which you cannot even have shipments of items subject to the EAR transit through Russia. So if you have an item from, say, China transiting through Russia, so not for export to Russia, but going through and then coming into the EU, or even the other way around, if a license would have been required for the export to Russia, you also would have had to have authorization for the transit through Russia. And so we could, of course, talk about more due diligence efforts here, but I think we've run out of our allotted time. Thank you for listening to our portion, and I'm going to hand it over to our colleagues at GBW now.
Yeah, hello. Also from our side, just share. So I hope you can see the presentation now. So again, good afternoon from Tanya and from myself to you. We are now giving you a brief overview over the sanctions imposed by the European Union on Russia. Actually, as you will know, there have been sanctions in place since 2014, so not all the sanctions are new, but of course the sanctions have been significantly expanded during the last 5 weeks following Russia's aggression against Ukraine. So what are the legal basis for the sanctions measures in place? The most important ones are the Russia embargo regulation, which is the 833, and the regulation 269, which targets people that undermine or threaten the territorial integrity, sovereignty, and independence of Ukraine, which is the famous person-related regulation containing the lists. Following Russia's aggression, there have been 4 rounds of additional sanctions which have now been imposed during the 5 last weeks. Of course, this can change every day, so these sanctions may be amended, further amended, and you have to take a close look, because usually those sanctions will enter into force on the same day they are enacted or on the following day. So one has to really pay close attention to any legal developments. 1 or 2, let's say, tools which could help you. For a long time, there have been no consolidated versions of the regulations 833 and 269. There's now an English version on the website of EULEX. So there you can find an English version of the consolidated version. And the German versions are on the website of the German customs. So there you can find a German text. You can also find one on our website, but both are on the customs website, which may help you for your practical review of certain scenarios. So I mentioned the regulation 269 as being in the center of the sanctions. There is one main provision, which is Article 2. This provision contains a freezing of funds and economic resources of listed parties, and it's sufficient that those parties that own, hold, or control other parties. So as Clinton mentioned, I think this is something we will discuss more broadly during the roundtable and in particular during the Q&A session. More importantly, even the famous prohibition of making available economic resources to listed parties, either directly or indirectly. I think this is one of the most important due diligence challenges for the companies, and honestly, even with now 20 years experience, and these provision of making available also exists since 20 years, has been existing for 20 years now. There are always new questions how to interpret it, and also the interpretation on the one hand by the European Commission and national authorities in Germany, for example, are not congruent, fully congruent. So there's another provision in the regulation 833, which is rather the trade-related regulation, but which contains a full economic embargo against 12 state-owned enterprises like Rosneft and Gazpromneft, and also their subsidiaries which are established or outside the European Union. The subsidiaries which are in the European Union are exempted, and this is also the reason why this is part of the regulation 833 and not 269, because otherwise the provision of making available would apply, and that would also target then the EU subsidiaries which are owned by those listed companies. And finally, this is supplemented by travel restrictions also for listed persons. In addition to the person-related sanctions, we have the trade-related sanctions in place. And the most important provision here is the provision to directly and again indirectly sell, supply, transfer, or export to any person, entity, or body in Russia or for use in Russia of dual-use items. So this is then referring to the Annex 1 of the dual-use regulation, 821 of 2021. Then you have a list of advanced technologies. This is new. This list is contained in Annex 7 of the regulation. There's a correlation table which you can use and which may help you. But these are items which are not already, or for most of them, are not already part of the Annex 1 to the dual-use regulation. What is not new are goods and technology for oil and gas. This Article 3 has already existed previously, but it has been expanded again. And to give you one example, drill pipes, for example, are listed in that Annex 2. Also, the energy sector is targeted by the lists of goods and technologies suited for use in oil refining. Here, one example is thermal cracking units, which are listed. So you have sector-related sanctions like those two lists, Annex 2 and Annex 10. And another sector which is now targeted is the aviation sector, again with a separate list, which only makes reference to Chapter 88 of the combined nomenclature. In addition to the aviation sector, there are also sanctions in place targeting the maritime sector. So maritime navigation goods and technology, which is navigation equipment and radio communication equipment. And again, there's a separate list of those items which are covered and this is the Annex 16. And finally, you have, this was part of the last round of sanctions, luxury goods with the long list from watches to perfume, etc., which are also covered. Again, even the selling of those items is already prohibited, and there's a threshold of for most of them of 300 euros, which is excluding VAT. And this is a statistical price, so usually the price paid or payable, which is declared in the export statement. So those are the sanctions on specific sectors, in addition the dual use items. And it should be noted that even any service and financial assistance related to those goods and technology are also covered and related to, as you can imagine, again, in the understanding of the authorities, usually has a broad scope of application. So it's not only maintenance of a specific good, but it can also be, for example, information by telephone, which is somehow related to that good. So you really have to be careful, even with services, when you somehow have goods and items which are relevant in your portfolio. And now I will hand over to Tanja.
Yeah, thank you very much. I'm glad to show you some more sanctions due to time restrictions. I will just draw your attention to a few of them. The EU has also imposed financial sanctions and restriction against Russia. Generally, the Russian state-owned companies, Russian banks and other companies shall be prevented to refinancing on abroad and to use foreign exchange reserves. Deposits from Russians exceeding 100,000 euros are not accepted anymore, except for payments for non-prohibited cross-border trade and sale contracts. Several banks have been excluded from the SWIFT system, such as Prompias Bank, Vneshekonombank, VTB Bank, and others. That means you can't use these banks for cross-border transactions anymore. But this also means that you may use other banks in Russia, and we know that Russian contractual partners are currently actively changing their banking accounts. Based on our experience, German banks are currently refusing any cross-border payments in rubles, but are performing euro transactions. However, they take longer than before. The provision of public financing and public finance assistance, especially via Hermes guarantees, has been stopped. Also there is a prohibition to supply euro in cash or euro banknotes to Russia. So if your employees are taking cash with them, make sure that they are only use the money for personal purposes and not for the benefit of third parties, even not for good business partners. Yeah, maybe it's already switched to the next slide. The next and our last slide is showing you some more sanction from other areas. Supplies and services related to arms and military are even more restricted or even excluded. This also covers any provision of assistance and services, as I said. Import of steel and iron products from Russia is banned. We have a ban on overflight of Russian aircrafts. That means that also traveling to and from Russia is currently very difficult. It's still possible via Istanbul, but very restricted. And we also have restrictions on economic activities in the Donetsk and Luhansk regions. And these restrictions are very similar to the already existing Crimea restrictions. And we also have a media ban on Russian channels. So you can't get this Russian propaganda anymore. I think due to the time line, I would stop with my short presentation here. And I think we have some more time to discuss more details in the Q&A round.
Yeah, many thanks to you all for your presentations. Just wanted to add that if you don't have to, you can ask us. We are glad to provide all the presentations. Just send us and drop us an email to redaktion@exportmanager-online.de. We will be glad to share the presentations of our 4 experts, and just drop us an email. So let's come to the roundtable, and I would like to start with our friends from the US. Clinton, I have a question. Your presentation addressed US export controls and sanctions, but the US also has a very robust foreign investment screening mechanism under the so-called CFIUS. Do you anticipate any changes to investment screening by CFIUS as a result of Russia's invasion of Ukraine?
Well, great question, Martin. Yeah, we do have a very robust screening mechanism, and it's handled by this the Committee on Foreign Investment in the United States. We shorthanded as CFIUS, and you know, I think in the past there has been sort of a limited number of investments reviewed for national security purposes coming from Russia. When you look at the statistics, Russian investment reviews are fairly small, but that doesn't mean that it doesn't now have greater scrutiny. And in fact, probably the most important thing to know about investments under CFIUS is, number one, if there is an investment by, say, a EU company into another EU company, if there are certain US entities or US assets involved in that, CFIUS could have jurisdiction. So a lot of folks think, well, if there's no, how does this involve me if the investment is in the United States? In a lot of cases, it's not just limited to United States investments. If there is some sort of US asset or US business involved. Number two is that CFIUS has been mostly a voluntary process up until the regulatory changes a few years ago. Now there's a mandatory process, but a lot of the transactions still fall under voluntary filing purposes. And a lot of companies decide they're willing to take the risk and they don't file, they don't do an investment screening with CFIUS. But that also means CFIUS can at any time, there is no statute of limitations, at any time they can go back and review a transaction that closed 4 years ago. We've even heard of some 10 years ago. CFIUS will reopen a case and review it for national security purposes. So if you had a transaction involving a Russian investor, even if it was a minority investor involving a US business, and that transaction was never reviewed, CFIUS could open it back up and take whatever action it deems necessary for national security purposes. So I do think not really any changes to the regulations per se, but I think there's going to be a focus on these past investments. They're going to reopen and take a look at those.
Thanks a lot. Nick, how do you expect China People's Republic of China with Russia to impact the overall landscape of Russia sanctions?
Thanks, Martin. That is a very good question. I don't think it's a surprise to anyone that the US has had a major focus on China from a foreign policy perspective for many years now. You know, the big ticket items that many people know are the tariffs the US imposed on Chinese origin goods. And for instance, the sanctioning of Huawei, the major Chinese telecom company, by placing them on the SDN list and creating sort of specialized sanctions related to them otherwise as well. And so given that historical focus, and given the fact that China and Russia have at least somewhat of a decent diplomatic relationship, I think there's the expectation that the US will closely scrutinize any business in China that they're facilitating on behalf of Russia. I would harken back a little bit to one of the things Clinton mentioned, which are these sort of international and domestic task forces specifically set up to enforce the Russia sanctions, including the DOJ klepto capture task force and this international repo task force. Given all of this and these resources, I would expect that China would be a major focus. US origin goods or technology or software going to China that could be transshipped to Russia, or other facilitation by Chinese businesses, Russian businesses as well. So in addition to that, these government agencies already had certain presences and people in these countries to try and review and enforce these laws as well. So I would look for the potential for Chinese companies to be supporters, designated as material supporters of SDNs, to the extent they may be working for them, or targeted for helping evade US sanctions or export controls laws. And even apart from sort of more intentional conduct, I think one of the major issues that will impact China specifically, given all the manufacturing there, is the expansion of both the foreign direct product rule and the de minimis rule. So for instance, in order to make a de minimis calculation and determine whether or not this end product manufactured in another country is subject to the EAR, you look at what content is controlled for the destination it's going to. So if you make a product in China and you're sending it to Russia, you have to do an analysis of what are those US origin components and how are they controlled under US law. So with these new rules placing more controls on a whole host of low-level items, something that normally wouldn't have been counted for de minimis purposes now is. So you're just going to end up with a lot more items that are subject to the EAR and require a license for Russia, even if they're manufactured in China. And then secondly, the foreign direct product rule is kind of the same concept. Are you relying on US origin technology or software to directly produce that end item? And if so, that end item could also be subject to the EAR. And because this is a new rule and so specialized and nuanced, it would be easy for companies to sort of trip up on these. So I think those are kind of the major points with respect to China.
Thank you very much, Nick. We already received some questions from participants, and I would like now to ask Thomas Maucher to ask his questions. I think it directs to the experts from the US.
My apologies, Martin. I don't think I'm hearing anything.
I also cannot hear. Maybe Martin, you can read it out if it's also via the chat, or.
Sorry again. Okay, haven't heard something, no problem. What are your experiences with the US Department of State? And then CAATSA, I don't know how to pronounce this. listed companies can also be extraterritorially relevant if they are significant transactions. What are significant transactions that do not involve US goods? Asks Thomas Maucher.
Do you want to take that one, Nick? I actually had a hard time hearing the question.
Yeah, no, absolutely. And if I understand correctly, the question was sort of about the U.S. Department of State's jurisdiction with respect to certain sanctions, particularly under CATSA, which was the Countering America's Adversaries sort of act that targeted Russia, as well as several other countries as well. And so, yes, you're correct that Department of State does have some involvement in identifying companies for sanctions under CATSA. And in fact, that's not the only sort of area where they do have some sanctions jurisdiction. I would say generally, a lot of these decisions are cross-agency. And so even if, Treasury and OFAC are primarily administering sanctions, the Department of State would often be involved. And so there, with respect to what is a significant transaction, typically under sanctions laws, it's basically up to the regulator to interpret that, and they tend to interpret it in such a broad way that it is very difficult to pinpoint what a significant transaction is, because that is a concept that's not limited to CATSA. It is across various sanctions regimes. And so with that in mind, I don't have the text of the specific way state interprets it in front of me, but the typical way it is interpreted is, they'll look at the number of transactions, the size of transactions, what type of transaction it is, things like that. And they tend to allow themselves a lot of flexibility in determining on a case-by-case basis what is a significant transaction. And I should also just mention that, as part of this, we've focused primarily from the export control side on the sort of dual use and general consumer goods perspective. As I said, that's regulated by the Department of Commerce. The State Department also has jurisdiction over military items. And so they administer what is known as the ITAR, the International Trafficking in Arms Regulations, as well.
Thank you very much. Maybe a question to all of you. The next US-EU Trade and Technology Council is scheduled to meet in France in May of this year. Do you think Russia will dominate the topics of the discussion in that meeting in May, next month already? Oh no, it's still March, so until Thursday. So do you think Russia will dominate the topics?
Curious to hear my friends at GVW, what you all think, or if you want me to go ahead first.
I can answer that question. I mean, definitely, I would say. I mean, I don't know the concrete agenda for the council meeting, which is about to take place. I mean, from the idea of the council, it's rather targeted to deal with more general issues. But I mean, there's close cooperation. In particular, the US is even named in the EU regulation as partner in all the sanctions enactments. So definitely, this will be the focus, I would say, of that meeting.
Yeah, and I might add, and Mary, we talked about this topic back in, what was it, October, about the TTC and how it seemed like sort of just people were going through the motions, but we didn't realize at the time how significant perhaps that coordination was between the US and the EU. Perhaps that played into how quickly we were able to do a multilateral effort on sanctions. And I think there are some working groups as well that are sort of important perhaps for this crowd. working groups involving, supply chain, export controls, investment screening. Technically, it didn't have a working group for sanctions, and I wonder if they're going to focus on that, not necessarily name Russia, but I think, the coordinated effort on sanctions. And then supply chain, they were really looking at China, it seems, right? The focus was very much on countering China. And so is there going to be a shift in attacking the supply chain involving Russia? So instead of involving semiconductors, are they going to address sort of the energy sectors or agricultural sectors in terms of supply chain? So those are my thoughts on it from the US side.
Yeah, China relations is a very important issue, especially for German companies. Many of the German companies who do a lot of business, sometimes more than 50% of their revenues in China. And so this is definitely an issue. A very practical question, Nick. What are some good resources to use to keep up with the quick pace of changes in the US-Russia sanctions?
Yeah, thanks, Martin. I guess I should start by saying, as Tanya and Marian mentioned, from the US perspective as well, these Russia sanctions aren't necessarily all new. Many of them date back to 2014 and sort of the original incursion by Russia into Crimea. And so that means from a US side, our regulations and guidance are a little bit spread out across a few different areas. I'll highlight some important ones. OFAC itself maintains 2 separate pages with respect to 2 separate sets of regulations that contain these restrictions. One is called the Ukraine-related sanctions, and there's a page on that sets out the relevant executive orders and guidance and directives under it. And then there is a separate page as well called Russia Harmful Foreign Activities. And that is another set. And it's important to look at both of those pages and understand all the restrictions and guidance underneath them. Because just because you're clear on one side doesn't mean you're clear on the other. And with that in mind, I would also mention that OFAC itself will publish what are known as frequently asked questions, and those are also available just on their general website, and they're linked from those pages I mentioned as well. And those provide very good guidance to help interpret these new regulations, which are often written quite broadly, and so it's the FAQs that help you really understand what they mean by some of the terminology that's used. So not only would I go to those websites, but I think it's a good practice to sign up for certain alerts from OFAC, which you can do on their website. There's a recent actions page that allows you to get emails when new actions come down. And then on the BIS side for the export administration regulations, there is also a lot of guidance on their website. Depending on how nitty gritty and how much you want to know about certain things, you can always sign up for Federal Register notices when new rules are published in the Federal Register. But I should also note that, of course, we publish client alerts and other sorts of documents to help people be aware of changes to not only sanctions, but general trade issues. And so you can sign up on our website to receive those alerts from us as well.
I don't think I can hear Martin. Can anybody else hear?
Thank you very much, Nick. In order to continue with let's say, with the US perspective,
I can't hear you. I don't know, Martin.
Yeah, I don't think I can hear Martin either.
Can you hear me?
Maybe I can add something with regard to the then, or Tanya also, as far as tools are concerned. I mentioned the consolidated versions, maybe just as a remark. In the meanwhile, there are also a lot of FAQs issued by the European Union, also by the German Ministry for Economic Affairs and Climate. And this is then again somehow linked to other FAQs. It's in the meanwhile already difficult to really have an overview of all the FAQs which are published. At least that is quite helpful for companies to have a look at those FAQs which are published on the website of the European Union and also on the website of the ministry. You should nevertheless be somehow be a bit careful. Be a bit careful because, and then that's quite difficult for companies. The answers to the questions are not always congruent. So you may have different answers from the European Commission on the one hand and from the German ministry on the other hand, which of course makes due diligence quite difficult. We can maybe come to an example later. Not to use too much time on it, but just to draw your attention to this fact. I don't know, Tanya, whether you want to add something.
Oh, no, thanks. I think that was quite comprehensive.
And it seems like Martin's trying to fix the technical side of his audio. I actually had a question for you all, Marian and Tanya. Do you mind if I ask you guys? So you mentioned, so I think in your presentation you say I must not, or companies shouldn't indirectly make available economic resources under EU sanctions laws to a US person. What are the obligations of a company though, and how far do they have to investigate here?
Okay, that's a good question, because I think maybe that's the questions we are asked the most, probably, Tanya and me. I mean, to start, let's say, with the basics. I mean, of course, you must check your contractual partner or the parties which are involved in a transaction. Usually, companies will use a screening tool for that. But it does not end with that tier one. You also have to do some further checks because, as I mentioned, there's a provision of making indirectly available economic resources to listed parties. So there may be a listed party which owns or controls a non-designated party. And if I do the check with the first tier ICO, there's no this party is not listed, then I have to go further and see, is there any party who owns that non-designated party? And of course, if I know the names, I can again go through the screening tool and check those, which I should definitely do. I can do some internet research, Google research. I can also go on the website and see, is there any information on the ownership, and I should really see, is this company owned by a listed company? At first, is it listed by another company? And second, is that other company also listed? So this is what I have to do at least. And if I have some suspicion, let's say, and it's really difficult with regard to Russia because you have many companies which are registered in Cyprus and British Virgin Islands, and in particular, if you have someone, one oligarch as the ultimate beneficial owner, it really gets difficult to do those checks. I mean, you do not have to engage a detective being on ground and doing on spot checks, but you have to do some background checks, at least with Russia. And I think the due diligence requirements are going even a bit further than in the past. When you take, for example, the Iran embargo regulation, I would say that the authorities maybe would require more because of the complex structures. On the other hand, one has to say there's a standard which somehow follows from the regulation itself, because in Article 10 of the Regulation 269, which is dealing with the listed person, it says if you do not know or if you do not have a reasonable cause to suspect that you violate the regulation, then you cannot be held liable. And the European Court of Justice, in a former decision regarding the Iran sanctions, has said this also extends to criminal liability. So this is a standard you always have to observe. So do I know it, or do I have a reasonable cause to suspect? And with regard to Russia, you have additional due diligence requirements. And now it comes to, I come back to my example with the FAQs maybe, because that's quite interesting and that makes it somehow difficult. In the past, and there's some guidance from the Council, which dates back to 2018, and also in the view of the German Ministry for Economic Affairs, if you have a non-designated party, which is, let's say, 49% owned by a designated party, by an oligarch, and then you have the other 51%, and there again you have someone with 49%, then you can already think of, is this control? And easier, or let's take an example which is a bit easier. You have one oligarch owning 20% and one oligarch owning 30%. Then the previous view rather was, I look at one designated party. So if he has 30%, he will not own the non-designated party, and the other one who has only 20% also does not control that non-designated party. And this was always, I would say, the prevailing view also amongst the authorities. And now if you look at the FAQs from the European Commission, they have one example exactly where you do an aggregation, like in the US. In the US, I think you mentioned that, Nick and Clinton. You look at the ownership and you can aggregate 20 and 30%. And the European Commission at least seems to be of the opinion that you can do it in the European Union too. Still, I think the German ministry and other member states take another view. But I would be cautious even in those scenarios where you have not a clear ownership, but different owners, and you take the aggregate of all, and then you come to an ownership of more than 50%. And just to, as a final remark, it's even not finished with the ownership. You have also look at the control, because it is also sufficient that someone who's listed controls a non-designated party. This, of course, again, is even more complicated in practice. But looking at the standard, I mean, you must have some indications, some red flags that there is some kind of such control. If there are no indications like that, I think you cannot be held liable. I don't know, Tanya, if you want to add something.
Yeah, I mean, just a few words. If it comes to Russia, the challenge is that you usually won't have a direct shareholding of a Russian oligarch in a German or European company. You always have very complex shareholder structures. You may, of course, use screenings and professional organization that will provide you with any information. But I always would suggest to try Russian sources to gain more information, to ask your contractual partner to provide you with more information. But Mayan said about control, we have seen this in the last years that many shareholders have just transferred their shares to related persons, to spouses, etc. That won't exclude any control, but if you have a similar name, that would give you a kind of suspicion that there could be still some control. So I would also suggest to use a broader range of resources to provide or to gain reliable information.
Yeah, and there are maybe to add that there are software tools which cover background checks. There are also providers who offer that they look at the ultimate beneficial owner. As mentioned, you do not have to be to have to investigate everything, but there are tools if you are uncertain to get more information. And Tanya mentioned the registered. I think there are also in the meanwhile already websites who list Russian companies and give some more information. So you can already find, I think one is org-info.com. I don't know who's behind that, so I have to do somehow a caveat, but we came across this. Those are sources which could eventually be used.
And there is also the website of the Federal Tax Services in Russia that provides you with excerpts from commercial register and any other information. It's unfortunately only in Russian language.
But accurate anyway.
Welcome back, Martin. We were doing the first GBW roundtable question.
Where we know our business is dynamic, as you can see. I think you can see the other background now. I don't know where the technical issues came from, but hopefully now you can hear me and see me precisely and clear. There's another question. There's another question to you, Nick. Do you anticipate further US sanctions against Russia, and what do we have to expect regarding this eventually new sanctions? Sorry.
Yeah.
Thanks, Martin.
Oh, go ahead, Nick.
And also to you.
If you wanted to go first. Go ahead.
Sure.
Sure. I think we'll maybe tag team this one. I'll just start with pointing out that among the sort of executive orders that form the basis of certain recent sanctions, for instance, the ban on the export of luxury goods to Russia, there were also provisions in there that allow OFAC to target other types of items at their discretion. And so that is a tool that's definitely in their arsenal and they could use at any time. And the same thing is with the import provision as well. There is a limited ban at the moment related to coal, petroleum, liquid national LNG, and also alcohol, seafood, and diamonds. And so at the moment it remains limited, but again, there was authority built into that executive order that would allow OFAC to expand that import ban at its discretion. And so typically when you see those sorts of provisions sitting there, they tend to be used when there's an escalation. And I would also note that there is something similar. There's currently an investment ban, new investments on energy in Russia. And again, there's a provision allowing OFAC to target additional key sectors and implement an investment ban there as well. And with that, Clinton, I'll turn it over to you.
Thanks, Nick, and I'll just be real brief because I think you mentioned some of the big ones. And it is kind of hard to predict because the US has to strike a careful balance of leaving enough room to continue to escalate, right, to make the threat of sanctions effective. So right now there's not a comprehensive embargo against Russia. One thing that we maybe haven't seen too much of is the use of the secondary sanctions, so sanctions against sort of these non-Russian individuals and companies that may be supporting Russia. And I'd just be very curious to see if they step up those efforts. That would be my comment on it. Also curious to know if our friends in the EU, if you guys have been hearing things in the news about further sanctions from your side.
And Clinton, maybe I would just add.
Yeah. Sorry,
I would just add one more thing is I think just yesterday there was sort of in the news an announcement, at least from the US side, and they said they were coordinating, of course, with our EU allies, that they were going to go after military supply chain as well. And so we might see additional sanctions related to that. And sorry, now to Tanya and Marion, if you have any comments.
I only heard that there is some discussion about more sanctions in the IT sector with respect to licenses, but that has been a couple of days before, so I don't know how concrete it will be and how it will look like. So that's from my side.
As Nick mentioned, I think this is very closely liaised. So if there's coming something from the US that will be coordinated with the European Union, I guess indeed with the military sector, I guess there will always be new people who will be added to the sanctions lists. And I think one is also looking at the moment where are let's say, possibilities to circumvent the regulations, to close gaps. This is something one is looking at now, in particular because the first sanctions were now imposed very quickly, and I think one has not seen every issue which now came up, also because of the many questions which have been taken to the ministries and to the European Commission.
Thank you very much. Let me add something. We received a lot of very, very good questions, but I would like to tell the people who asked all those questions, send it via chat, that we are going to discuss that in the Q&A session. Let me first add a question to Tanya. Russia has also adopted some countermeasures, mainly to protect the capital market, the Russian capital market. But also Russia addresses other areas and markets. Could you briefly summarize these? What impact do they have on foreign companies?
Yeah, thank you very much. I think it's, if we are talking about EU and US sanction against Russia, it's also important to have a look at the countermeasures. They are, as you already said, mainly aimed at protecting the capital market in Russia, but also they are containing an export ban. The Russian countermeasures have been implemented by presidential decrees, by governmental orders, supported by several instructions and clarifications of the central bank. Let me just name a few of them. The first presidential decree as of 28th of February provides for an obligatory sale of foreign exchange income by Russian exporters from cross-border contracts. Later on, there has been implemented a possibility to apply for exemptions. Also, Russian residents are not allowed to transfer a foreign exchange to their own accounts. And also there has been implemented a few exemptions from that, especially to ensure the financing of foreign branches. The granting of loans and trading in securities is only possible by between Russian residents and foreign persons from so-called unfriendly states. It's only possible upon the written consent of a governmental commission. There has been an order which is regulating unfriendly states. These are all states that have imposed sanctions on Russia, so all EU member states, the US, Canada, etc. Initially, there has also been a prohibition or the requirement for a governmental consent to have transaction on real estate, but now this has been eased again a little bit. According to another presidential decree, the Russian state-owned companies, but also other Russian companies may fulfill their obligations from cross-border loan agreements with lenders from so-called unfriendly states in rubles. And there has been implemented a very specific procedure how this can be fulfilled. Maybe there's another very interesting countermeasure that has been recently implemented and that could also influence cross-border contracts. According to a presidential decree as of 18th of March, the central bank is entitled to set a maximum amount of advance payments for cross-border contracts. And recently, the central bank has set this maximum amount as of 30% of the contractual value. There are some exemptions for fuel and material purchase for the operation maintenance for vehicles, but actually, this is a very broad countermeasure. And yeah, lastly, there has been an export ban introduced by a presidential decree supported by a governmental order. This is governmental order number 311. It contains hundreds of items that are not allowed to being exported from Russia. And you may find many like technical equipment, pharmaceutical products, medical products, vehicles, etc. in this order. Lately, there have been implemented some more exemptions. So goods originated in Russia can be exported. So one have to, if you have a Russian subsidiary, for instance, and you have still a kind of equipment in Russia you want to export outside, you have to look if you fall under this governmental order. And if so, maybe an exemption applies, and you may also apply for exemption at the Russian customs.
Thank you very much for this overview. There was one question raised to Marian or Tanya to repeat the website you've mentioned before regarding the background check. Maybe we can do this after the webinar, and you will send to us the address or the addresses, and we can send them to the participants. But regarding the items you've mentioned that are banned from the export or the regulations, where can companies can look it up? Is there also kind of website, or do we have to learn Russian for this?
Unfortunately, all these orders are issued in Russian language. So it could be useful to have somebody in your company that may translate it. I know that the Düsseldorf Chamber of Commerce that has a special crisis center, they have translated the initial order and the attachment that contains all the items. I don't know if they have updated the translation, but I would suggest to have a look there. We can also collect all helpful links afterwards and send it to you, and I can also include this link if you want.
I think this would be extremely helpful. Thank you very much. And to the plenum, yeah, Düsseldorf Chamber of Commerce. I think the number of visits on their website will increase strongly in the next hours. Another question to Marian regarding lists of goods. How can I find out whether my good is covered by the new Annex 7 to the EU-Russia embargo regulation?
I think the most workable tool is to use the correlation table, which I briefly mentioned during the presentation. The numbers in the Annex 7 are a bit different than in Annex 1 to the dual use regulation. There are some similarities, but it's not exactly the same. And if you then want to find out, is my item really listed, you can take that correlation table, and this correlation table demonstrates the CN number, so the number of the combined nomenclature, 8 digits. And if you look at that, this is you can find out whether your item falls under Annex 7. Of course, this correlation table is no legal instrument as such, but if you, and usually the companies know their items the best, if you take a close look at that correlation table and then compare it with your items and you document it, I would always recommend to make documentations also regarding the provision of making indirectly or directly available economic resources. So if you do any checks, do documentation that you have done the checks, but also with regard to your items. And I think then this standard of liability, which I mentioned, is also met with respect to the items.
Thank you. And we got a comment of a participant. He says, okay, you can also translate Russian regulations or the by this automatic translators like DeepL, but I'm sure an expert additionally has to look into it if it's properly translated, because I think it's related to quite a lot of money if something goes wrong with this translation. But as a basis, I think it should be okay to get an idea what it's all about. Tanya, many of those cross-border contracts with Russian contractual partners can no longer be fulfilled due to the sanctions. What do foreign companies have to pay attention to respect with their contracts?
Yeah, first of all, I would suggest to have a deeper look at the contract itself and to figure out what law applies to the contract. Is it subject to German law? Is it subject to Russian law or to any other law? Do the contract contains any specific provisions for termination, any specific force majeure rules? If, for instance, a German company is not allowed to supply or to fulfill a certain contract with a Russian contractual party due to EU sanctions, this is also from a civil law view, this is a prohibition to fulfill the contract, and the German company, the German contractual partner, would be released from any liability, and even the EU sanctions, they also contain a release of liability. But the Russian contractual partner may try to raise claims against the German company in Russia and to enforce its claim in Russia if the company has any assets there. From a Russian point of view, a EU sanction might be a force majeure circumstances, and you may try to also get released from any liability for non-fulfillment. There is a broad Russian court practice starting in 2014 with respect to EU and US sanctions, whether they are force majeure or not. Russian court practice is very reluctant to accept sanctions as force majeure, but they don't totally refuse it. So it's you have to be very careful to fulfill all the requirements that have been settled and set up by the Russian court practice. I would strongly not recommend to just stop the fulfillment of the contract without any justification, unless you are ready to pay damages. I would strongly recommend to figure out the entire background, and if you just want to stop the fulfillment of a contract just due to reputation issues or political decisions to stop your business in Russia, I also would try to have some negotiations with your partners to find a common solution for that.
Thank you. We'll stay with you, Tanya. Many foreign companies are thinking of leaving Russia, or at least reducing their business, and there is a lot of discussion on the threat of expropriation. I hope I got it right. How do you assess this risk, and what is your advice to companies?
Yeah, this is also a good question. Because actually, at the moment, nobody knows the next development of the legal procedure in Russia. There is indeed a draft act that is providing for the possibility to appoint a so-called external administrator for Russian companies with foreign shareholders if these companies will leave Russia or terminate their activities. The preconditions, what currently in this draft act, that the foreign shareholding is more than 25%, the book value of the company is at least 1 billion rubles, and or the company has more than 100 employees. And if the management of the company ceases its activities in Russia or terminates its activities in Russia by leaving the company, for instance, by reducing the value of the company significantly, or by terminating material contracts, by terminating 1/3 of the employment contracts, there could be a court decision that would appoint such external administrator, and this external administrator shall continue the company and shall protect the employees. And by doing so, the external administrator is allowed to spin off certain assets, to sell these assets, which is in fact an expropriation. So this is the draft act. I mean, it's a little bit more comprehensive, of course, but nobody knows if this act will be come into force, when it comes into force, and what will be the real content. So actually, the situation is now a little bit unsatisfying for companies that are planning to leave Russia. You may think about a liquidation procedure, which is very long, similar to a liquidation procedure in Russia and Germany, and needs some formal measures and administrative efforts. Companies may think about alternatives, how to stop their business and selling their business or selling their shares, or just to continue the business unless it's not prohibited by US sanctions.
Thank you very much. I think it's time for the Q&A session now. But before, I would like maybe to ask you all, do you see certain signs of kind of, I don't know, de-escalation in terms of at the moment at the situations? We can see it on the in the news side, what happens in terms of peace talks, etc. But is it more, do you see more escalation or de-escalation regarding the sanctions regulations?
Well, from the U.S. side, I do not see any de-escalation, and it's somewhat rare to see rollback of sanctions. It does happen, right? Over time, it does happen, but it's certainly not something I would anticipate happening anytime soon. Again, it's really hard to predict these things.
Sure.
Yeah.
And I agree with Clinton, and I would just add that, you know, the U.S. perspective is typically that sanctions are in place to change behavior. And so until there would be a change in behavior on the part of Russia, I just would not anticipate any rollback. If there were to be a rollback, I would also anticipate that it would be coordinated very closely with the EU and other allies, given the way it's been coordinated in the rollout as well.
I think the same is true for the European Union. I fully agree. I mean, we are not the politicians. We do not decide on the regulations themselves. But I also do not see signs of de-escalation, even if there are talks. We are not participating in the talks. We do not know what's really going on there. So I agree also with Nick. I think it's also kind of perspective, background for those sanctions measures. And I mean, there have no been political developments like now, but also the Crimea sanctions are already in place now for many years. And I could imagine that also these sanctions somehow, maybe not all, but many of them even remain in place, even if there's any, I don't know, whatever solution. Again, we are not the politicians to decide on that.
We're not. But anyway, many thanks for your comments. Yeah, we received many questions, and one of those questions is by Roger Korn, or a construction company. He asks, if you decide to turn down your activity in Russia completely, what has to be done to avoid this countermeasures by Russia?
I think it's a question that I could answer. I mean, as I said, this draft act on external administration hasn't been implemented yet. So at the moment, you may close your business in Russia without any essential countermeasures. But nobody can estimate if this legal act that I have described could come into force tomorrow. So it's very difficult to predict, and it's very difficult to say. As long as you have the possibility to somehow freeze your business in Russia to avoid these negative consequences, maybe you could choose to wait another month or so. If you really decide to leave the country, you may, of course, start a liquidation procedure. And for doing so, you have to implement like corporate decisions, etc. If you have already transferred your assets outside of Russia, you may estimate if the risk of such expropriation is really an essential risk for you, or maybe you could even live with such risk. So it really depends on the concrete situation you have and on the concrete assets you still have in Russia, and if there's a possibility to transfer the assets abroad, or if you have the possibility to sell the assets within Russia or the Eurasian Union.
Thank you very much. A special question to Marian, a very specific question on luxury goods. Article 3H Annex 13. We are a manufacturer of medical devices, and some of our spare parts for these devices fall under this article, but are definitely not luxury goods. The product only fall under the custom tariff number, which is mentioned in this annex. Is there an exception to Article 3 for supplies in connection for medical technical goods? Asks Daniel Volkmar, Fresenius Medical Care. I know, very, very specific. Marian, please.
Yeah, that I would really have to look up. I mean, in general, there are some exceptions to some provisions in the regulations as far as medical or pharmaceutical devices are concerned, where you can ask for an authorization, or whether there's an exemption. If one looks in Article 3H, I cannot see an exception in the wording, which would mean prima facie that these are not exempted. So if they those items which come under which, if they are really luxury goods, and I understood they fall under that annex, probably there's then no exception, I would say. So, if of course the value, I mean, there's a threshold for the value, and you have the definition of item. That is of course all has to be met. But if all those criteria are met, I would say this could fall under the annex.
Okay, thank you for this instant consulting from your side. Thank you very much. We have another question regarding Dubai, the Emirates, from Joachim Schneider. Hello, have you seen information about Russian companies trying to buy material via distribution in Dubai or the Emirates? Interesting question, maybe from, let's say, both sides of the Atlantic.
Well, I guess I should just make a comment that I had a slide on transshipment, and I had highlighted China as a transshipment risk, but that was just an example. Dubai, UAE, of course, has been known for many years as a hotbed of transshipment. For instance, to Iran to get around the U.S. embargo against Iran. But in terms of actual recent news involving Dubai, no, I have not seen that, unless anyone else on the panel has.
Okay, thank you very much.
Maybe I can add.
Sure.
We've
please.
also not have come across concrete cases yet, but of course I could imagine that there will be efforts to somehow circumvent the regulations. Just to mention that there's also a provision of circumvention in the sanctions regulations, and of course, if you have a new customer, you should be more due diligent than if it's a long-standing relationship with your customer. All this now has to be taken into account because it's I think let's say natural reaction by Russian companies to get to source their items differently now. One really has to be careful.
Yeah, and
please.
And let me also add about you mentioned diligence. I don't know if we talked about it in detail, but these end user certificates that we see on the U.S. side, and we've worked with Marian on the EU side, end use declarations, end use statements, these documents that when you're dealing with a customer, especially in a place like Dubai, it's almost like required, even though the regulations don't say you have to necessarily get it in all instances. It's best practice, standard practice to get the certificate that there is not going to be, for instance, an unauthorized diversion for end use or an end user.
Okay. Question of Peter Brinke goes in the same direction. There are spare parts for a manufacturing machine for medical devices. According to the current regulations, these should be shipped to Russia without any problem, even if they contain US goods. Sounds a little bit like a comment, but if we take it as a question, because the export should be done via the UAE, the Arabic Emirates.
I'm happy to try and tackle that. So if the question is related to if you have a foreign-made item that has U.S. content, that item could be subject to the EAR and require a license to Russia, and so or to any other destination. It really depends on what is that component that was incorporated and what is its value in relation to the overall item, and how is that component incorporated. So that would require a look there. I'd also look at the foreign direct product rule and whether or not that might be relevant. And it seems like there was a mention that it might go through the UAE, and as everyone mentioned, that is a diversion risk, and certainly you'd want to do due diligence on that. I wasn't sure if that was meant to be the end destination or transit through, based on the question.
And to add to Nick's comment, I think there are some provisions in the EAR, and you have to look very carefully, that exclude food or medicine from the restrictions, but I don't think that applies across the board, and I'm not sure, if it would apply to this specific situation. for medical devices. But there are some provisions in that, and you just have to figure out whether your specific export or re-export falls under the one that mentions food or medicine.
Thank you. Now, a question especially to the OFAC experts. Maybe you can raise your hands if you are one of those. How do you assess the appropriateness of measures to be compliant to the 50% rule of OFAC? Deep research is very complex and expensive, especially for SMEs. Is there any known experience from your side? Maybe first you can explain the OFAC as is.
Yes, absolutely. We're happy to tackle that one. So OFAC is the Office of Foreign Assets Control under Treasury, and they are who administer the sanctions laws and regulations of the United States. And under the 50% rule, as mentioned earlier, any entity owned 50% or more by one or more blocked persons is itself considered a blocked person. And so, this is a question we get a lot. There is no magic bullet in order to say I've absolutely complied. I should start with the proposition that OFAC considers its regulations to be strict liability. In other words, you don't have to know or have reason to know of the violation of the sanctioned person's ownership in order for it to be a violation. That said, they typically will look at what you knew or had reason to know when going after an enforcement action. And just a basic proposition of compliance with both OFAC and the export control side as well is that you take a risk-based approach to your due diligence and your compliance. And so what that would mean in this context is I would consider Russia to be much higher risk than other jurisdictions, particularly due to these sanctions on the oligarchs who have, as we know, massive amounts of money and are invested across a variety of different types of industries. And so things that you can do, of course, it was mentioned these sort of reports that can kind of help you assess ownership. You'd want to, of course, see what you can just find out through general internet research. Another thing that we recommend is similar to like an end use or end use certificate, or maybe in conjunction with it, have the company you're dealing with attest to its ownership and spell out what that ownership is, and then screen everybody that they've said they're owned by. Those are some tips. Unfortunately, there's no magic line that you've crossed and you can say I've absolutely, checked all the boxes here and I'm at no risk. But doing reasonable and risk-based due diligence is the right approach.
Thank you.
Maybe I can add what we have also seen. It's not with respect to OFAC, but more general, is that Russian counterparts come up with legal statements from law firms. I don't know whether there are still any law firms in the US or in Germany giving advice to certain clients, but this could be a mean if it's a reliable law firm, but there again, one has to take care that it's not self-written by the Russian company, but really something from an external source which is reliable. It could be a means to get additional comfort, but again, you always have to be also with that diligent.
Thank you. Just a follow-up question from Christian Leidig, SMS Group. Is the 50% rule also applicable in the EU?
No, first, we have no 50%, but it's more than 50, so 50 and is small,
50
so
plus.
50.01, 50 plus. And as mentioned, we have on the one hand ownership, which is 50 plus OFAC rule, and we have a control. So there is some kind of 50+ rule, and as mentioned, there's some discussion whether you can aggregate it like OFAC would do it or not. But you also have to look at the control. So it's an additional element, and also if a listed entity or listed person, oligarch, has less than 50%, he may still control the non-listed entity if he appoints the management, if he influences the daily business with its decisions, etc. So one even has to be more diligent in that respect. I would even think that something like the 50% rule, it's already complicated enough, but that would give more legal certainty for EU companies if we had the same system.
Thank you. Roger Korn asked, is there a 50% ownership rule for EU sanctions as there is for SDN?
I don't know exactly. I mean, for the EU, just we have this provision of making available directly or indirectly economic resources. There you have this check of ownership and control. Just to mention that if you sell, supply, transfer, or export items which are listed, it also says directly or indirectly. So even in that scenarios in the EU, you have to take care and check make some background checks so that you are not risking to deliver something to indirectly to a listed listed Russian. It does not even have to be listed to a Russian person in Russia or for use in Russia. That's the wording.
Okay. Questions are really very specific. So we can see that all the topics are of high importance for our participants. There's one question from Stefan Pipperwright. Article 5AA of now 833/2014 reads, it shall be prohibited to directly or indirectly engage in any transaction with. Could you elaborate on the definition of transaction mentioned in the Article 5AA? For me, this is a little bit too complicated, but maybe you've got an answer.
Tanya, I can also answer, but transaction is really everything. So it's really a full embargo covering that. There's no formal definition, I think, in the introductory part of the regulation, but it's meant really to cover everything, because the intention is to have a full embargo on those entities except for their German-based subsidiaries.
Okay. Many thanks for those questions. If I forgot someone, apologies for this. We can for sure afterwards answer these questions, especially when you're in direct exchange with our experts. So I would like to come to the point of compliance. What are some of the most common compliance challenges you have seen impacting your clients? This goes, I think, to maybe we start with Washington.
You want to take this one, Nick? I can go as well.
Sure, I'm happy to start, and maybe you can add in. I think we talked about a lot of the high-level ones, which is like compliance with the 50% rule, and just knowing your end user, watching for diversion. There are a few other things, though, that are kind of unique under these sanctions. For instance, on the export control side, this ban on luxury goods. Typically when you're in the export control world, you're looking at the export control classification number and making an assessment based on that. And so you should have like your list of how your items are controlled and know whether or not it's controlled to your destination, and of course do your screening for end users. The sort of issue with the luxury goods rule is that these would be typically EAR 99 items. So they wouldn't be listed, they wouldn't be subject to specific controls, but they are subject to controls for this embargo. And so it requires you to look very closely at those regulations line by line and determine if your article is listed there. There was a question earlier about certain medical items that may be on the EU list that you might not think of as luxury goods. I would say the same is absolutely true on the US side as well. There are articles on there that you wouldn't necessarily think of as luxury goods. There is, of course, high value apparel, textiles, things like that, are watches, but there's also things like certain camping supplies, certain types of vehicles and engines that you might not think of as luxury as well. So it really does take an analysis of the list item by item. And there's also a similar new restriction with respect to oil refinery equipment as well, which similarly requires you to look line by line at those items. So I think that's kind of an important, unique compliance choke point under these.
And the one thing I would add is we mentioned protecting the company, your company, by sending out end-use certificates and statements. But we've also had companies come to us that have received them, right, from vendors or customers asking your company to attest that you're compliant with all US and EU export controls and sanctions laws. And it's a very broad request from your clients. And so there is, depending on your relationship with that third party, you may or may not want to respond, or a lot of companies find themselves in a position where they create sort of a standard response so that they don't have to reply specifically to what was requested by the company, but just say, hey, here's our, we do intend to remain compliant with the regulations, and sort of have a broad statement like that. We see clients do that as well. So I think that that is a kind of a recent compliance challenge. Yeah.
Yeah, I mean, the same is true. I absolutely concur with Clinton. We have also seen this in the European Union, that you are asked for statements. I would give the same advice. And as far as compliance changes are concerned, again, the provision of making indirectly available or selling, transferring, or exporting items indirectly is the most challenging part. Also, some companies have pending applications for authorizations with the German competent authority, BAFA, and BAFA is now starting to write to companies whether they are still interested in a decision because they would be denied anyway, let's say. Still, you have your contractual partners, and I think it would be good to have a negative decision from BAFA, even if you know that this will be negative in the contractual relationship with your partner, so that you can really demonstrate if the Russian partner comes up with damages, etc., that you were not able to get a license from the competent authority. So I fully understand BAFA that they have a lot of work currently, they have a lot of queries, and you won't get an answer if you ask them something currently, because there's so much, and they are happy about any procedure that do not have to follow, but an application they have to decide on. But I think it's in the interest of many companies to have a formal decision. I don't know, Tanya, whether you have any additional thoughts.
Yeah, I would add a recommendation with respect to cross-border contracts. I've been informed from several clients that they received some questions from Russian contractual partners to amend and to conclude some supplemental agreements to existing contracts. I would be very careful to sign such supplemental agreements and to have a broader look at them. I always would suggest to include sanction clauses into any contract and with Russians. This has both sides. From one side, this is also a compliance issue to give you a representation from the Russian partner. On the other side, there will be, I'm pretty sure, some thoughts from your Russian contractual partners that they don't want and or not allowed to include some such provisions. This is a negotiation issue. Russian law is not explicitly prohibiting any representations from the Russian contractual partners about their shareholders, about the compliance with EU sanctions. Maybe there will be some criminal liability in the future, but nobody knows that this yet. So I would be also careful about this and try to include special provisions from your side into such contracts.
Thank you. A very interesting question regarding the timing. If somebody already has received a license for export to Russia before the new sanctions came up, how to deal with this? Asking the authorities, or where's the deadline, let's say?
I can start from the EU side, and then maybe Clinton and Nick can say add something with respect to the US perspective. If you get a license from BAFA, it always says this remains valid until the legal situation changes. So the legal situation with respect to prohibitions and the authorization requirements have changed. So any license which you have not yet made use of, but which was already granted, will usually not longer be valid. This will be automatically. BAFA will not approach you, but you have to check as a company by yourself whether your license is still valid, and then you have to compare. Is this something where the legal situation really changed with respect to my specific item or not? In case of any doubt that this will be the case, because now we have a provision for any dual-use items listed in Annex 1 to the dual-use regulation. So really most cases, nearly all cases, your authorization will no longer be valid, and this will be indeed automatically.
Then how about the US perspective?
Yeah, there's sort of that general rule is when you have the export authorization, it's still valid until, expressly revoked. But that being said, in the license applications, you have to list very specific details about the parties you're dealing with. And so if you received a license either from BIS or OFAC involving a Russian end user that was later placed on, let's say, the SDN list or on the entity list, that those regulations, those designations are effective now. And so I would be hesitant. I would not try to rely on that license. And perhaps Nick can speak to experience in reaching out to licensing officers. I think it would be helpful to communicate with the agencies, and specifically your licensing officer, on whether these licenses are valid, because I'm positive both agencies are actively reviewing licenses right now.
Yeah, that's exactly correct. We know that they're reviewing these licenses, and I would hesitate to act on them without contacting the license officer. And just one other point I would make is both BIS and OFAC can have jurisdiction over the same transaction. So just because you have a license from one doesn't mean you have authorization from the other. And so I would also take that into consideration. If you have a BIS license, but OFAC designated this person, that's also an issue as well. So just kind of keep those dual jurisdictions in mind.
Thank you very much. Yeah, 4 p.m. I think these were very fast 2 hours. Many thanks for your participation in this webinar that really got into deep regarding the Russia and Belarus sanctions. Please, to the audience, please feel free to contact our experts directly. I'm sure they will have an open ear for this. You will receive the presentations for sure. Yeah, and more up-to-date practical background and analysis on foreign trade you will find regularly on ExportManager-online.de. And I have to do some publicity for our next webinar on UK, not Ukraine, but UK, also an interesting topic in May. So you also will be informed on that. Now, I have to say thank you to the experts. Thank you to you, the audience of this webinar. And yeah, let's all hope that peace will come soon. Have a good day.
Thank you.
Thank you. Bye.
Thank you.